Good morning to everyone on the West Coast and good afternoon to everyone else. Good to see everybody here, even though I can't actually see you. But we're going to talk about the changes that have come about with the ending of the COVID-19 flexibilities. So as we get started, Anna, if you want to move to the next slide. Of course, because we're attorneys, we have to let everybody know we have a disclaimer. This does not constitute legal advice. It's for informational purposes only. For legal opinions and for your specific situation, please schedule a consultation with one of our attorneys and we'd be happy to assist you. The lawyers told me to say that. So we're going to move on to WR. Here at WR, our mission is to provide our clients with the best experience through strategic legal services, predictive technology solutions, and inclusive collaboration. And we help our clients journey forward with their immigration matters. All right, a roadmap. What are we going to talk about today? We're going to talk about the end of COVID-19 flexibilities and what must be completed by August 30th if you are in that camp. Who can use the new alternative procedure for virtual inspection of the I-9 documents? What is the alternative procedure? What employers need to know about the new Form I-9? And then we're going to talk about the new DHS Pilot Program. Just briefly. Okay, so let's get into the nitty-gritty, the ending of COVID-19 flexibilities. Can't believe that it's already been over 3 years since we first did a massive shutdown, essentially, with everything happening due to COVID-19 and the pandemic. Back in March of 2020, when all of us were going remote. I know some people were already remote, but a lot of us went remote. Some businesses actually had to stop for a period of time, hoping that the pandemic would just kind of blow over. And then we settled into a new quote unquote normal. So during this time, the immigration attorneys were actually working with the government to figure out, hey, we need to do something with the I-9 process because employers are still hiring individuals. They still have work to do, but given the seriousness of COVID-19, in person was very, very difficult in many industries. So the government, which was Department of Homeland Securities and the Immigration and Customs Enforcement Agency, they created a remote or otherwise called virtual review of the documents for the I-9 purposes. This procedure for flexibility was initiated on March 20th of 2020, okay? The initial flexibility permitted employers to use the remote review if there was no company representative located at the work site. That was not the case for most employers. They may have had a few people at the work site, even security staff. Back then, the government said, we don't care if you have one person on site, then you need to do the Forms I-9 in person for new hires. Well, we know that that was really almost impossible to do. And a lot of employers hadn't really flipped over to thinking about the use of an authorized or designated representative. Well, fast forward to April of 2021, DHS tweaked the flexibility for the remote review, and it could be utilized by the employer if the employee was working remotely due to COVID-19. Okay, we know that a lot of individuals during that time were hired remotely to be permanently remote, not just due to COVID-19. So this flexibility by the government kind of got morphed into a new way to virtually review the documents for Forms I-9. One of the requirements of utilizing this COVID-19 flexibility with virtual review was that a company has to have a written policy that explains how they are going to implement a remote or virtual review of the I-9 documents in order to complete the process. If you are one of those employers who did not create a written policy, guess what? You can do so now. It's now is not too late. So if that is something that you have not yet done, make sure that you complete or create your policy, kind of look back at it, what did you do, and put that down written. The government in May of this year announced that they were going to end the COVID flexibilities on July 31st of 2023. I'm sorry, that was in October of 2022 that they announced the flexibilities would end in July of 2023. And then in May, the government said that we would have until August 30th to review the documentation, to do the physical inspection, which was required of all employers to physically review the documents of the individual when they came back to work in person on a regular or consistent basis. And with everything that has been going on in the world, within our industries, it really wasn't top of mind for a lot of companies to do the physical inspection of the I-9s when employees came back to work. And many of them didn't. They're still remote. So now we're in the situation where we have until August 30th to complete a physical inspection or an alternative procedure. All right, so we're going to do our first quick poll. Was your organization enrolled in E-Verify between March 20th, 2020 and July 31st, 2023? The answer, or the choices are yes, no. You were enrolled prior to July 31st, but not since March 20th. And then what is E-Verify?
Okay, I'm going to give it just a second. Looks like we have quite a few people voting. And I'm going to close up the poll. And we have some interesting results that I will share. It looks like most of you were in E-Verify, with just a few of our participants not knowing what E-Verify is, maybe.
Well, that's awesome because we don't have a majority of employers that are enrolled in E-Verify in the quote unquote real world. But there are over 1 million employers enrolled in E-Verify, which is fantastic. So I'm going to make sure that we're focusing a little bit more on alternative procedures since we have a higher number of individuals attending who are enrolled in E-Verify and had been. So we're going to talk about a little bit of the nuances that goes along with enrollment in E-Verify. And for those of you who don't know what E-Verify is, not who it is, but what it is, we'll talk about that as well. Okay, so by August 30th, employers who completed a virtual or remote inspection of the identity and work authorized documents for employees that were hired between March 20th, 2020 and July 31st, 2023, a physical inspection must be completed of the employee's work and identity documents, okay? That information, the actual review, has to be notated in the additional information field of Section 2 in order to prove to the government that the documents were physically reviewed. And then you would include the date, which would be the month, day, and year, and who they were reviewed by. The full name and title of the individual is preferable to just initials. Okay, that is the basis of the physical inspection and the notation of the Form I-9. If the representative conducting the physical review is different than the representative that conducted the virtual review, what do we need to do? Okay, the USCIS guidance has said that the new representative must note their name in the additional information field. So what I had up above there, their name, their title, preferably. If they are a designated, i.e. authorized representative, they should use that as their title, which would be designated representative or authorized representative, not the title that they hold in their profession. You know, if someone goes in to see their CPA, the CPA should put designated representative and not CPA. And then that information should be notated in Section 2 under the additional information field. ICE, Immigration and Customs Enforcement, has actually said that their preference is that the new reviewer for the in-person review actually complete a new Section 2 and sign the certification section so that they are signing under penalty of perjury, right? That's their preference. It's out there. You may do that, or you may choose to proceed under the USCIS guidance. So for this physical inspection, employers can use the October 21st, 2019 version of the Form I-9, which is still in effect, or you can use the August 1st version of the Form I-9, which was just released on August 1st. It actually didn't even get posted until later in the day on August 1st on the USCIS website. Okay, so you want to complete the physical inspection, or, and this is what we'll talk about, the alternative procedure, if you are an employer that is eligible for the alternative procedure. And you guessed it, the only employers that are eligible for to use the alternative procedure at this time are employers that are enrolled in E-Verify and had been enrolled in E-Verify during the employee's time of hire. Okay, I keep saying we have until August 30th to complete this physical review or the alternative procedure review. I want to draw your attention to something that was in the press release that was issued by Department of Homeland Security on July 21st, which is when the information was initially published in the Federal Register to say, hey, this is going to be published formally on July 25th. But in the press release, DHS said this, and I'm going to read it because I think it is very informative and helpful to a lot of employers. If an employer is otherwise compliant with the law and regulation and had followed the COVID-19 flexibility guidance, U.S. Immigration and Customs Enforcement, otherwise known as ICE, will generally not focus its limited enforcement resources on Form I-9 verification violations for failing to complete physical document examination by August 30th, 2023, particularly where the employer can show that it has taken timely steps to complete physical document examination within a reasonable period of time. So for those of you who might be having significant stress right now, how am I going to get the remaining 2,000 employees, completed with this secondary review? Under what DHS has said, right, you want to make sure that you are at least proceeding as fast as you can or as best as you can under the circumstances to complete the review by August 30th. Right, so hopefully that helps a little bit. Our second poll. Okay, I just want to see, does your organization use an electronic Form I-9 system? Yes, no, or you have no clue.
Okay, we've got a lot of votes coming in very quickly here. Let's see, let me give it a couple more seconds. But we have a clear winner, I can tell you already.
Cool.
Right.
And the winner is?
Close that up, and the winner is?
Yes.
Almost everybody uses the electronic Form I-9 with just 13% no, and then a few stragglers who do not.
Awesome. Awesome. So the reason that we're asking this is because the electronic I-9 software is different depending on which software provider you use. So the information that I'm providing here may or may not be exactly how your electronic software provider can do this process. I know there's different steps with different providers. Some are a little bit more sophisticated in how they've incorporated the end of COVID-19 flexibilities into their program. Others are not. They're a little bit more antiquated, I guess. I don't really want to put it that way, but they might not have as sophisticated a system, or frankly, just not enough time to code everything and get it into place. So where I can, I will reference some of the things that I know some electronic service providers have been doing. But if you are unsure of what your electronic service provider is capable of doing or has been recommending for you with the completion of these ending of COVID-19 flexibilities, I would recommend speaking with them directly. And if you have any additional questions, you can always reach out to one of our attorneys at WR to assist you with that process. So we're going to talk about this in general terms, and I'll sprinkle in a little bit of information that that I know of just from what clients have informed us. Okay, so we're going to talk about the alternative procedure. This alternative procedure is the alternative to doing a physical in-person review of the identity and work authorization documents, where you, as a representative of the company or a designated or authorized representative, is physically in person meeting with the employee, right? So a designated representative is anyone that is at least 18 years of age or older. per USCIS. They do not discriminate on who can be a designated representative. Within your own organization, you can put restrictions on that or guidance on who may or may not serve as a designated representative for your employees. Again, be consistent with your restrictions so that everybody is being treated fairly. With the designated representative, which I'm just going to talk about before I go into the alternative procedure, because there is a portion of some of these I-9s that will need to have a physical inspection because some of the electronic programs might not allow for easy access to things. But if you're going to do the physical review, if you have a designated representative, you can provide guidance to that designated representative. You can have your standard language guidance of what that representative needs to do because they're acting on your behalf. Okay, so that's one of the things with the in-person review of the documents. A lot of organizations want to use a notary. In pretty much any state other than California, a notary can serve as a designated representative as long as they are not serving as a notary and notarizing the document. In California, under the Business and Professions Code, a notary cannot, even in their non-notary capacity, serve as a designated or authorized representative unless they are a licensed and bonded immigration consultant. That's to protect individuals in the state of California. So just for those of you who are in the state of California and maybe using a designated representative, be really careful about the use of notaries. Pretty much it's best not to use a notary in California for that purpose. So what is the alternative procedure? Under the alternative procedure, and you may utilize this if you are a qualified employer, and the employer must have been enrolled in E-Verify at the time that they completed the remote or virtual inspection of the employee's identity and work authorization documents. And the employer must have created an E-Verify case for the new hire. And the initial or remote virtual review must have been conducted between March 20th, 2020 and July 31st of 2023. Okay. What is a qualified employer? You have to be a qualified employer in order to utilize the alternative procedure. A qualified employer is an employer that is enrolled in and in good standing with E-Verify. Well, what is good standing, you might ask? Well, E-Verify has a brief statement on their website that defines what is good standing. Good standing means that the employer is enrolled in E-Verify with respect to all hiring sites that use the alternative procedure to remotely examine documents. The employer must use E-Verify to confirm the eligibility of newly hired employees in the US. And this is the key, the employer must comply with all other requirements of the E-Verify program. That's a huge statement there, because it's very broad. It doesn't tell us a lot of information. So hopefully the Immigration Service will provide FAQs to further define this a little bit, because some employers may have skipped E-Verifying some employees by mistake, or there could have been a situation where they were E-Verified late, or who knows, right? There are mistakes that were made along the way. Does that mean that the employer is still in good standing? Our belief is that if an employer has done everything that they should do to comply with E-Verify, and if they have a few mistakes along the way, if they haven't been called out by the E-Verify monitoring and compliance unit to say, look, you've done really bad, you've really messed this up, then in those situations, it's going to be really difficult to confirm definitively that an employer is not in good standing, right? So stay tuned. We're trying to get additional information from USCIS on what could trip an employer up in such a case that they would not be considered to be in good standing. So for now, unless there have been egregious errors or the employer's been contacted by the monitoring and compliance unit to say, you've misused E-Verify. If you've done everything otherwise that you feel needs to be done, you've complied with the memorandum of understanding, you have enrolled or created cases for all of your new hires, then you can, potentially or more likely than not be considered to be in good standing. So that's, again, alternative procedure. The employer must be a qualified employer, which means that the employer is enrolled in E-Verify. When you're completing or using the alternative procedure for an employee, the employer must have been enrolled in E-Verify at the time that the employee was hired. And the employer must have created a case for that specific employee. And then the employer must be in good standing. So you may have a situation where you enrolled in E-Verify in 2021. So now your ending of COVID-19 flexibility is going to be bifurcated, right? You're going to have some employees that were not hired while you were enrolled in E-Verify. And therefore, those employees will need to have the reinspection completed using the physical in-person process, which is through a company representative or a designated authorized representative. Okay, so you might have a situation where some of your workforce will require the physical inspection. Some of your workforce may be eligible for the alternative procedure. So it's really important that if you are an employer that has not been enrolled in E-Verify since March 20th of 2020, you make sure that you keep a process together so that you're documenting the employees that were hired while the company was enrolled in E-Verify and a case was created for them, and the employees that were hired before the company was enrolled in E-Verify. You want to make sure that you're very, very careful about that so that you don't get into trouble. If ICE comes knocking at your door, which I hope it does not happen, but if you were ever to undergo receive a notice of inspection and go through an I-9 audit conducted by ICE's Homeland Security Investigations team, you want to make sure that you've at least completed the physical in-person review for those who aren't eligible to use the alternative procedure, and then you can utilize the alternative procedure for the other individuals. So that's step number one, right? We want to make sure that you're using the alternative procedure appropriately and when you can use it. So we're going to go to the next slide, please. Again, I want to impress upon you, because this is, it's not rocket science, right? But there's a lot going on here. There's a lot going on. And there was so much that we went through in the past 3 years, so many different things that happened from a hiring perspective. Companies have multiple sites, et cetera. So the employer has to be enrolled at every hiring site in the US that allows virtual verification under the alternative procedure. Put that a different way, if you have 10 hiring sites and 4 of your hiring sites are under the MOU and enrolled in E-Verify, then you can use E-Verify for those hiring sites that are listed on, in E-Verify as your hiring sites. The 6 hiring sites that are not listed in E-Verify, you would not be able to use the alternative procedure. So for those of you who use E-Verify, you know that you can register or have notify the USCIS and E-Verify unit of the hiring sites. How you also, and again, this is to make sure that there's no discriminatory action taken, because again, you don't want the government after you with discrimination in the hiring process or in the I-9 review process. We have another agency of the government, which is the Department of Justice's Immigrant and Employee Rights Division, or section, I apologize, Immigrant and Employee Rights section, that oversees discrimination within the I-9 process. So when you're conducting the alternative procedure, you want to offer that consistently to all, in this case, not new hires, but all those new hires at the time that they were hired during COVID-19, right? So if you have a hiring site, you're enrolled in E-Verify, you want to offer alternative procedure to all those employees. The other thing that an employer needs to have done is to undergo an E-Verify tutorial that includes fraud awareness and anti-discrimination training. The E-Verify unit is providing this additional training. For those of you that have been enrolled in E-Verify for a while, you're not required to retake or to take this new training in order to participate in the alternative procedures. You might, when you log into E-Verify, they might say, hey, there's a new tutorial. We recommend that you take it. I recommend doing that, absolutely, because then you can check the box. But if you were previously enrolled and you met all the requirements for your tutorials, you don't have to do the new tutorial in order to take advantage of the alternative procedure. Okay, so it's a little bit more. You can go on to the next slide, please. Okay. Some of the common questions that we have had come up are, can the employee present the same documents that they presented when the Form I-9 was initially completed? All right, so say you're doing either physical inspection or the alternative procedure. Under the alternative procedure, you must request that the employee send to you copies of their identity and work authorization document or documents. They have to send them to you in advance of the next step, which is that you have a video conference with the employee. So now you're actually looking at the documents that were sent to you via photocopy, and you're having a video conference with the employee so that you can look at the employee, look at the documents that they provided to you, and say, do these reasonably appear to be genuine? Do they reasonably appear to relate to the individual that I'm viewing via this video conference? Okay, so under the alternative procedure, you now have to make sure that you obtain the documents from the individual, you do a video conference with the individual, and then you save the documents that the individual provided to you. You must save them with your Form I-9 documents. Okay, so that's another step that you have to do with the alternative procedure. Question, which is not on this slide, but a question that comes up is, hey, I did that when I initially hired this individual. The individual sent me their documents. We did a FaceTime because I didn't want them to just email me the documents or fax them. I wanted to be able to see that person. We did a video chat. We talked about the weather. I reviewed the documents. I completed the Form I-9. Yes, even if you did that initially, because it was a virtual review of the documents with the individual, it doesn't comply with the physical inspection requirement that has to be completed by August 30th. So now government says, yep, even if you did that, you're going to have to do it again under this process. Okay, so now you have you're obtaining the documents from the individual, either you're physically in person with them, or you're doing the alternative procedure where you have a video conference. Can the employee present different documents from those that they presented at the time of initial completion of the Form I-9? Right, so let's break it down. Individual gave you their US passport at the time of hire. Now they're providing to you a driver's license and an unrestricted Social Security card. Can you accept them? Because it's not the document that was initially provided at the time of hire. Yes, you may permit the individual, actually you're supposed to permit the individual to provide different documents. You cannot force them to provide the same document or documents that they provided at the time of the initial completion of the Form I-9. So if an employee presents the same document now that they provided 2 years ago, what if that document's expired? What if US passport that they provided to you expired in November of 2022. They were hired in April of 2021, so the US passport was valid at the time that they presented it initially. So therefore, you can accept that expired US passport for purposes of this review by August 30th. Okay, so the key is that the document or documents had to have been valid at the time of initial presentation when the I-9 was completed. If they're presenting different documents at this time, when you're doing the re-inspection, then the documents that they are presenting at this time for the re-inspection have to be valid, right? So they have to be valid now. So if someone were to present to you driver's, you're completing the Form I-9 today, they give you a driver's license that expired a week ago, you cannot accept it. It's the same rules that apply for when you're reviewing the documents for the initial completion of the I-9. If they're presenting them to you today and they are not the same documents that were presented previously for the initial I-9 completion, then they have to be valid as of the time that you're conducting that review with them. So I'm going to look at some of the questions here because I want to answer them in real time as much as possible. So if an HR representative, if the company meets the requirements to do the virtual alternative procedure, you can do that alternative procedure with the virtual review via a Teams meeting. That's absolutely fine. They have to have the camera on, right? They have to have the camera on. But you can do a Teams meeting. Another question, how do you enter hiring sites with E-Verify for remote employees? That's a really good question. One of the options potentially is to create a hiring site that is all of your remote employees and maintain your remote employees within that one hiring site. Again, you want to talk to your counsel about that. To make sure that it's being set up properly, but that could be an option for me. Let me see. What is the best practice for out-of-state new hires where we can't physically inspect the documents? If you are not enrolled in E-Verify or you're not a qualified employer that can partake of this alternative procedure, then in order to do that, you would want to enlist a designated, or the other term that we use is authorized representative, who would be essentially the company's proxy. And that could be the individual's household member, if they have a roommate or they have a spouse, that individual could serve as the company's designated representative. You'd want to make sure you have clear guidance to provide to that designated representative and your employee to complete the Form I-9. Let's see, be some example. So let me clear this up. Someone is asking about the FaceTime example, but you can't use that. What I want to clear up is that if on the initial completion of the Form I-9, you did the virtual review in order to complete the Form I-9, and you did the virtual review using FaceTime or Teams or Zoom in order to utilize the COVID-19 flexibilities. If you did that and you are, or at the time, you would fit the definition of a qualified employer, right? One that was enrolled in E-Verify at the time. So you're like, hey, wait a minute. I was a qualified employer under this definition in April 2021. We did a FaceTime or a Teams video review when I completed the Form I-9. Why, or do I have to complete this re-inspection by August 30th? The government has said, yes, you do. Even if everything that you did back in April of 2021 kind of fits the requirements and the definition of qualified employer and alternative procedure, that doesn't count. So in a way, you're kind of doing it all over again. Okay, so that's the distinction, is that everything that was initially reviewed remotely by between March 2020 and July 2023 has to go through either a physical inspection or an alternative procedure inspection. You have to do one or the other. See, I'm the representative, however, I work remotely along with an arch. Let me get back to that question. And then what if we didn't have front and back of original documents? Can we still do the alternate method for these employees? So that's another really good question. If you at the time of completing the initial I-9 review only had the copy of the front of the document, right? A driver's license, there's something on the back usually. Then when you're doing the alternative procedure, if the individual presents you with that same document again, right, because the individual has to provide you with copies of the document, it's okay if at the time that you completed the initial Form I-9, you only have the copy of the front of the document. Now, when you're completing the alternative procedure, make sure that you get copies of the front and back of the document or documents from the individual and keep those with your Form I-9. So that's a good question, but it's okay if you didn't keep a copy of the back of the document initially when you completed the Form I-9. So here's some of the examples that we wanted to go through, right? When you're completing the I-9 additional information fields with remote and physical notations where it's the same representative who did the initial Form I-9 and review of the documents, who's now doing the re-inspection. I'm going to call either both the physical inspection and alternative procedure, just refer to both of those as a re-inspection, right? So either way, if the same person did the initial review that's doing the re-inspection, then that person would include in the additional information field COVID-19 documents physically examined on month, day, year by, and that person can use their initials or just use their full name. I think it's clear if they use their full name, but I understand if they're going through hundreds or thousands of these, they want to use their initials, that would be fine. Make sure that you also have listed in the additional information field when the remote inspection was completed, right? So you want to make sure that it's noted remote inspection completed, and that should be the same date that the individual completed the certification section in section 2, where they said, I completed this on X day and here I'm signing my name. You want to make sure that you always have in the additional information field that there was a remote inspection and then the COVID-19 documents physically inspected. So we'll move on to our second example. And what if we're when completing the re-inspection, there's a different representative who completed the re-inspection than who completed the initial inspection. In this situation, the explanation is a little bit more involved or definitive in that you're saying COVID-19 documents physically examined on, again, month, day, year, by, and then you put the full name of the individual and their title. If the individual is not employed by the company, then you would want to make sure that they use the title of designated representative, or they could use authorized representative as their title so that it's clear that they're a designated representative and not an employee of the company. Again, you also want to make sure that that box includes information that the remote inspection was completed on the initial date that it was completed. Okay. We're blowing up here the October 21st, 2019 version of the Form I-9. You could potentially utilize the August 1st version of the Form I-9 as well. Another thing to mention here is if you wanted to use the new version of the Form I-9 or the old version of the Form I-9, you can use either, right? Both are valid right now. But if you have a different representative who is reviewing the documents now than who reviewed them initially, you can have that new representative complete a section 2 and sign under penalty of perjury. Because also recall that this person who's doing the reinspection is reviewing the documents. So if the documents are the same as what's in section 2, nothing needs to be done. If the individual is presenting different documents than what are in section 2, which were presented at the time of initial hire, then guidance says that representative can squeeze the information about the new documents in the additional information field. I recommend completing a new section 2 so that the appropriate fields are completed, nothing gets lost in translation, and it's clear both for you internally and if you're ever audited by ICE, right? So if the same documents are presented, you can utilize the same form that was used with the initial review. If you have different documents being presented by the individual at the reinspection time than what they presented initially for the I-9 review, my recommendation, just to be cleaner, is to do a new section 2 so that it's cleaner. You still put the notations in the box, absolutely put the notations in the box, but it gives you more room to actually include and make sure you don't miss a field for each of those documents that are presented. That's one of the guidelines that USCIS provided, as well as as ICE. So that's just think about that when moving forward. Okay. The other thing, as I was talking, I knew I wanted to say something that I was reaching in my brain for. So sorry about that. Some of the electronic service providers don't have the ability to add that information to the additional information field. So in those situations, they actually require a new section 2. So don't be alarmed if that's what the electronic I-9 service provider is requesting that you do. That's completely fine to complete a new section 2. In some cases, it's actually cleaner to do it that way. It's just a preference of what's going to help you get through however many I-9s you have to review through the reinspection process by August 30th. Our third example here is completing the additional information field when using the alternative procedure. If you're using the October 2019 version of the Form I-9, you would state in the additional information field, alternative procedure examined on month, day, year, and then the individual's information. So again, it would either be the initials if it's the same person doing the reinspection that did the initial inspection, or the full name and title of the individual if there's a different individual doing the reinspection than did the initial inspection. Again, as much information as you can provide, and again, I understand limited time, limited resources, but to the extent that you can provide the name and the title of the individual, it can be helpful going forward, especially if you need to kind of understand, recreate what you did. So that's something to just make sure that, to the extent that you can, include the the full name of the individual and their title. Right. And then our example 4 is if you're using the new Form I-9 with the alternative procedure for reinspection. On the new Form I-9, which is the August 1st, 2023 version, in the additional information field, which is a big box on the form, there's a little box in there that says, check here if you used alternative procedure, right? So you can use that if you're utilizing the new version of the Form I-9. Right, so here's the flow chart that we put together. If your brain isn't already trying to explode right now with everything that is an option, or keeping it straight what you can or can't do, again, you'll have our slides, so you can look at this flow chart a little bit more in detail. We tried to squeeze everything on here. And my team member did a fantastic job of squeezing it all on here to go through, can you use the alternative procedure? What is the process for an alternative procedure? What's the process for the physical inspection? So I'm going to leave this for everyone to, to look at when you download the slides. Feel free to use this as a reference, which, again, right now looking at it, my brain is ready to explode, but it does flow, and it's helpful if you're someone who's visual and wants to connect the dots. So this is something to keep in mind to hopefully help guide you through the process. The new form I-9 is where we're going to go to. But let me take 1 second. I just want to see if there's a Q&A in here. A question in the Q&A. If we are using the previous I-9, which is the October 2019 version, can we just add the verbiage from the new I-9 under additional comments? USCIS guidance says to include the specific language that COVID-19 physically examined, or you would say COVID-19 alternative procedure utilized. You want to make sure that you document it that way. And it's preferable to use it in the additional information box. That's the field that the government wants to see that in there. If it's on the form somewhere, it's on the form, right? You have it on the form somewhere, but to make it easier for you going forward, if you're doing an internal I-9 audit, or I hope you are never audited by the government through the Homeland Security Investigations Agency, but in that case, it will be very helpful to make sure that it's all in that area. Okay, so what do employers need to know about the new Form I-9? The new Form I-9 is effective August 1st of this year, just 10 days ago. You can use the version, which is I don't know if we want to say the current version, right? Because now we have August, we have two current versions. So you can use the October 21st, 2019 version until Halloween of this year. Scary thought, until October 31st. You must use the August 1st, 2023 version as of November 1st, or Day of the Dead this year, 2023. Okay, so current version, which is dated October 2019, you can use until Halloween, but beginning on November 1st, Day of the Dead, you must use the August 1st, 2023 version. Just like the October 2019 version, there is a Spanish version of the Form I-9 and instructions. However, only employers that are located in Puerto Rico may use the Spanish version of the Form I-9. And I'll just reiterate that. Only employers in Puerto Rico can use the Spanish version of the Form I-9. If you are not in Puerto Rico, what I have recommended is, as an employer, you can present the employee with the English and Spanish versions of the Form I-9, list of acceptable documents, and instructions if it makes it easier for them to understand what's written on the form, but they have to complete the English version of the Form I-9 unless the employer is in Puerto Rico. And that also gets into preparer translator situations as well, right? And I'll go into that in another minute. So what has changed on the Form I-9? It's one page. I feel like saying, the Form I-9 is here. It's like Steve Martin the jerk. The new phone books are here. Do you remember that? Super excited when the new I-9 came out. It's only one page, which is good and bad. I mean, for those of you who remember the old one pager, it was nice not to have to use 2 pages for all these years we've been using it. But it's also, for those of you who are not using an electronic software provider, it's squishy. The fields are really, really small, so you have to really pay attention. Another change is that no longer is the word alien listed as an individual status. So I used to call them the box 4, right? Box 1, US citizen, box 2, non-national or non-citizen national, box 3, lawful permanent resident, and then box 4 were aliens authorized to work in the US. Now that the term alien is gone, thank goodness. I never really liked using the word alien because everybody is a person. They're not from outer space. So the new term is non-citizen. As I said, smaller fields. If you're using the paper version of the Form I-9, this is just heaven right now. NA is no longer available, or no longer must be added to some of the fields, right? So if you went through the process where an individual forgot to put NA in the email field, that's not going to be a problem going forward. It can be left blank. And then the other big change is that the alternative procedure box is now in the additional information field of the Form I-9. Okay, so this is what a small version of the new version of the Form I-9. You'll notice that the edition date is down in the lower left-hand corner. So one way that you know which version you're using, look in the lower left-hand corner. The other thing is if everything is all on one page, you know you're using the new Form I-9. And again, here's the new box for the alternative procedure. It's down in the very far corner of the additional information box. Hopefully it's easy for everybody. So you would check that if you're eligible to do the alternative procedure. The list of acceptable documents, which is affectionately referred to as LOAD, list of acceptable documents, is included with the new version of the Form I-9. And what's new about this list of acceptable documents, it has in the list C section 7 slot, it has links to what documents may be considered by the government as optional or alternative documents that could be used for list C. The other thing is down in the lower portion, the very far bottom of the Form I-9 list of acceptable documents is a link to I-9 Central, where an employer can go to obtain additional information on what documents are acceptable for purposes of proving work authorization and or identity. We want to let you all know, some of you may know this, others might not. The list of acceptable documents is actually missing about 50 documents. Seriously, there are about 50 documents that have come into existence because of new policies, right? Afghan parole, the Ukrainian program, automatic extensions of green cards, automatic extensions of EAD cards. There's been a lot that has gone on in the last few years that have significantly increased the number of documents that are acceptable for purposes of proving identity and or work authorization. So as an employer, if you receive a document that you're like, I have no idea what this is, you can check on I-9 Central to see if it's accepted. To save you a lot of pain and headache and time, you can always reach out to a WR immigration attorney to help you decipher if that document is acceptable or not. There's also contacted Department of Justice Immigrant and Employee Rights section as well that can help with some of those documents to see if they're acceptable. So that's one of the things that we have with LOAD. And we have a supplement A, right? So our Form I-9 now consists of the one page, which includes section 1 and section 2. Supplement A is the preparer or translator section. So you can see here that this is where an employee will complete if they used a preparer or translator. You no longer have to worry about making sure the employee checked one of those boxes that they used a preparer or they did not use a preparer. One thing to make sure is that at the top of the supplement, the individual employee's name is referenced so that you can be sure that you're combining the two, the Form I-9 and the Supplement A together so that it doesn't get misplaced with somebody else's documents if you don't have a name on it. We also have Supplement B. Yes, that's right. There's a Supplement B. This Supplement B takes place of the section 3 of the Form I-9. This is for rehires, re-verification of work authorization, and name change. Again, at the top of this, you want to make sure that the employee's name is listed. And then you complete this similarly to how you completed section 3. One thing to note, the form and or instructions say that an individual is to provide documentation for their name change. The rules haven't changed. An employee does not have to provide documentation of their name change. If someone comes to you and says that they've changed their name, they might need to provide a document to you for other purposes, but not for purposes of a name change for the I-9 completion. And then the new DHS pilot program. So in the last minute, we're just going to go through. This is not a program yet. It's just at the comment stage in the Federal Register. And on our next slide, we have some of the things that is for the pilot program. This is for non-E-Verify employers, non-E-Verify employers. Again, not yet available. A lot of restrictions, 500 for your employees. You have to report to the government, the number of new hires, the number of people who have asked for physical inspection. They're on site. You're going to be overseen by Department of Justice, Immigrant and Employee Rights section. There's a lot of restrictions. As you might be able to tell, this really isn't one of my favorites, but it is not yet available. And most of you on this meeting are enrolled in E-Verify, so this wouldn't be applicable to you either. So there will be new programs coming out. So I know we have a few Q&As left. I am going to go through and answer those Q&As, and we'll send them around when we send our slides and our PowerPoint, our slides and the recording. These are where you can get your resources, the WR team, the handbook for employers, I-9 Central, and E-Verify. Hope you all have a wonderful afternoon. And don't forget here, the poll, if you need term credit, please fill out this poll so we can get that certification to you. And I really appreciate you spending your time with us. And we hope that we see you again soon. Thank you so much.